Good afternoon, ladies and gentlemen. Thank you for coming this lunchtime, and I hope that between us we will be able to unravel some of the legal mysteries that face the current commercial shipping environment. Piratical attacks on merchant vessels that have occurred in recent times in and around the coasts of Somalia have struck at the very core of maritime security and safety. A partial understanding of the difficulties faced by governments on the one hand and commercial shipping interests on the other lies in the fact that the accepted legal definition of piracy has two significant components. The first, the public law concept of a crime against civilized nations and their trade. And secondly, the private law concept of piracy as a contractual risk under policies of marine insurance and contracts of carriage. Two aspects, a public and private aspect, both of which, as I hope we'll see, play a significant role in the present difficulties. Piracy as a defined term, like risks associated with war and conflict, has a long history. In his judicial arbitration handed down in 1982 in a case called the Bamburi, which concerned the fate for insurance purposes of some 80 vessels marooned in the Shatt al-Arab during the course of the long Iran-Iraq war, Mr. Justice Staunton, as he then was, said, "The political history of the Western world for the last 200 years is reflected in the cases on war risk insurance." So as to matters of definition, a crime under public international law and the concept of universal jurisdiction. In an 1820 case in the United States courts, Mr. Justice Story said, "All writers concur in holding that robbery or forcible depredations upon the sea is piracy." And in the same jurisdiction, the United States, in 1864, there was quoted in argument a speech by John Marshall, later Chief Justice of the Supreme Court, who in part said this: "A pirate under the law of nations is an enemy of the human race. Being the enemy of all, he is liable to be punished by all." And in our own courts, the Judicial Committee of the Privy Council in 1934, in the celebrated universal jurisdiction case called In Re Piracy Iure Gentium, it was said, "Piracy may be committed on the high seas by any national on any ship." Any national on any ship. A person guilty of piracy has placed himself beyond the protection of any state. He is no longer a national, but hostis humani generis, and as such, he is justiciable by any state, anywhere. This universal jurisdiction has found its way into the present international convention governing certain of these matters, the United Nations Convention on the Law of the Sea, 1982, Article 101 of which says, in definition of piracy, that the concept concludes any illegal acts of violence or depredation committed for private ends by the crew or passengers of a private ship on the high seas against another ship or property on board such ship. That introduces a new concept which complicates matters, the concept of private gain. Article 100 of the same convention states that signatory states have a mutual duty to cooperate to bring pirates to justice. We shall see how difficult that has proven to be as we proceed. So thus far we see the concept of a public law crime, justiciable in the courts of any country, and that the pirate perpetrating an act for private gain is liable to find himself apprehended and potentially tried in any court which can seize him and take jurisdiction over his actions. The concept of private gain, however, has sought and included quite a number of nuances as the cases have developed. In a 1909 case in the United Kingdom, the Court of Appeal said, "Piracy consists in the pursuit of private as opposed to public ends. Primarily, the pirate is a man who satisfies his personal vengeance by robbery or murder in places beyond the jurisdiction of any state. So again, we see the concept of a private criminal act committed on the high seas beyond the jurisdiction of any state. This has led to other niceties of definition as English cases have developed over the years, where there is a clear interaction between the public law concept and the private law risk in contracts of carriage and policies of marine insurance. In the 1923 case, the Filia, a yacht with French passengers and crew, was seized and disappeared off the coasts of Turkey in the aftermath of the First World War. Neither vessel nor crew nor passengers were ever seen again, and investigations locally showed that they had been seized by a local warlord and the crew and passengers put to death. The case came before the English courts to determine whether the loss of that vessel for marine insurance purposes was a loss caused by piracy, or whether it was some other insured peril. And the court had little distinction in finding that this was a loss by seizure and not by piracy. The reason being that because the individual concerned, the warlord who ordered the acts, had arrived, as even a brigand may do, at a position of considerable authority, and was virtually controlling, as a dictator might do, the region in which the seizure took place. So here was a criminal act, most probably committed for private ends, but done in the so-called name and authority of a local warlord who, on investigation, had assumed power in the region, and that the attack was carried out by forces, individual or collective, under his jurisdiction. So not a loss by piracy. Seizure by local authority, even if hostile. In the 1977 case concerning the vessel Andreas Lemos, a party of men boarded the vessel while she was anchored off the port of Chittagong and under cover of night stole mooring ropes. They did not offer violence to the crew, and there was no hostilities. The case came before Mr. Justice Staunton, who has heard many cases in this area in the commercial court, and he had some very interesting observations to make, this time in the context both of the public law area where jurisdiction might be taken and the private law concept and a policy of marine insurance. He said, amongst other things in his judgment, "I see no reason to limit piracy to acts outside territorial waters. In the context of an insurance policy, if a ship is in the ordinary meaning at sea, or if the attack upon her can be described as a maritime offense, then for the business of the policy of insurance, she's in a place where piracy can be committed. Theft without force or threat of force is not piracy under a policy of marine insurance." So theft of mooring ropes without violence, but within the territorial waters or the area of the port of Chittagong could, for those purposes, be piracy if that was proven, which it wasn't in that particular case. In the case of the Salem in 1979, which was a vessel the subject of a huge conspiracy to defraud oil companies and others and import oil into the Republic of South Africa at the height of the apartheid sanctions, the vessel was scuttled and the case came before the Court of Appeal in a number of issues. It was the subject of a significant judgment by Lord Denning, who described the events as a gigantic ship used for a gigantic fraud. But because there was no violence offered, at least none shown, he said there were no pirates here because there was no forcible robbery. This was purely a conspiracy and a scuttling, if one could put it in those mild terms. In contradistinction, in the 1998 case of the Petro Ranger, a vessel was seized by Indonesian pirates, all her cargo stolen, the crew put us over the side in lifeboats, the vessel taken to several ports, dimensions and description and superstructure were changed, and the vessel was used for piratical activity, thieving other cargoes, and the vessel changed her identity. It was accepted, both in arbitration and in the court, that the theft of the cargo, the violence offered to the crew, putting them over the side in a lifeboat, and the use of the vessel for piratical activities did count as piracy for the purposes of an exception in a contract of carriage. I turn to the case of the Panagia Tino in 2002, a case in which I was involved when I was in practice. This vessel was trading between the Black Sea and the coast of India, and she suffered an engine breakdown in the Gulf of Aden. The master and chief engineer decided that they needed to seek refuge near to the shore and did so on the northern coast of Somalia. The vessel was boarded by pirates and held to ransom. This was probably one of the earliest cases which had occurred in what has now become a long stream of unfortunate and well-known incidents. When the first ransom demands were made to a team rapidly assembled in London to try to deal with this novel and unexpected situation, erudite words from elders came through. It was suggested that the attack was in retaliation for the despoilation of the coastline and maritime heritage of Somalia by foreign fishing fleets who had ruined the fishing grounds, destroyed the livelihood, and threatened starvation to the inhabitants of many ports, and had also resulted from significant pollution caused by ocean vessels belonging to other nations overspilling their ballast and other dirty materials into Somalian waters. There's no doubt that these arguments had some merit, as everybody reflected at the time, but unfortunately, there was more than a hint of criminality, which of course has almost become the norm. Negotiations followed towards a ransom payment, but many of the difficulties faced by present governments and ship owners were found in that case. The vessel was flagged and registered in Cyprus. She was managed in Greece and crewed by Filipinos. Whilst the ransom had been put forward on essentially humanitarian grounds, it became clear that none of the government interests concerned had any significant role to play in the release of the vessel. When contacted, most were very content to point to another party and say, this is not a matter for national governments, it's for somebody else to hang on to. A NATO flotilla was operating in the area at the time, 3 warships found by the German and Spanish navies, and it became clear during negotiations with their ministries and their commanding officers that their intervention was highly restricted. Their sphere of operations was limited, and in the absence of real threats to loss of life, there was nothing operationally or legally that they were able to do. So after several weeks of rather fraught negotiations in an area that was completely new to all of us, recommendations were given by security and hostage and ransom experts that the ransom should indeed be paid. And what comes from this case was that payment of a ransom came down at the end to a decision by lawyers and commercial insurers rather than governments. And that is where the problem currently resides. Governments have found it very difficult to respond in the early stages, and all the ransom payments which have been made notoriously over the last 5 or 6 years have in the main had to be generated by commercial interests, most notably marine insurers holding the risk for piracy for the vessels concerned. This has reached the stage where in the 2009 case of Maysfield and Amlin, which was heard in the commercial court last year before Mr. Justice Steele, the position had been reached that 7 years after the Panagia Tino case, which we've just discussed, that on the basis of a significant number of similar cases, there was uncontested expert evidence, and it was accepted that Somali pirates were not interested in stealing or discharging cargo, and that once a ransom demand had been made and negotiations opened, there was a high expectation that a ransom would be paid. That is a fairly extraordinary situation, that uncontested expert evidence before the English commercial court was accepted, and indeed had to be accepted. But once a piratical attack or hijacking had taken place, there was no alternative but to release the vessel upon payment of a ransom. 7 years is a long time, but unfortunately, it's almost the case that a precedent system has been reached. So how has this situation been allowed to develop? What has been the response of the international community? We need to look back in other areas to see how the international community has responded. And in the late 1960s and the 1970s was the first threat to the safety of modern post-war aviation. None so than the hijacking of 4 international aircraft which were landed at Cairo by representatives of the People's Front for the Liberation of Palestine. The crew and passengers were held to ransom, and although subsequently released, one of the aircraft was destroyed on the ground at Cairo by the terrorists. 3 were flown to an airfield in Jordan, where they were similarly destroyed by explosives. This became the subject of a very significant arbitration heard before the late Lord Justice Michael Carr. For our purposes today, we need merely to note that that and similar hijackings at the time was responded to by the international community with a series of international binding multilateral conventions seeking to enhance post-war aviation and security. We sadly know that this problem continues in a different framework today. In a maritime context, the attack on the passenger liner Achille Lauro in 1985, leading to the well-publicized murder of an American citizen at the port of Alexandria, had similar results. The international community responded urgently and quickly, with the community passing in quite short order the well-known SUA, Suppression of Unlawful Acts at Sea Convention of 1988, more recently updated with protocols in 2005. And for our purposes today, the significance of that convention is that it set out a binding criminal jurisdictional regime for crimes of robbery and violence against ships and also fixed platforms. It was a very far-sighted convention, and the intention was the parties signing up to it and ratifying it should be able to enact it into their own municipal legal systems and make it a binding criminal regime within that particular state. And that, ladies and gentlemen, is one of the areas where the piracy problem has arisen, because there is no equivalent binding criminal international convention onto which that particular crime can hang. So the SUA Convention was the response in a maritime context to the equivalent to the hijacking attacks on aircraft. That takes us forward to the tragic events of 9/11/2001 and the attacks on the United States of America. The international community responded in a similar way. The United Nations Security Council delegated to the International Maritime Organization an obligation to formulate as soon as possible an international code of safety and security equivalent to the SUA Convention. And in 2004, most nations signed up and ratified the International Ship and Port Facility Security Code, which was a groundbreaking convention binding together shipping and shore interests, operators, national governments, and flag states for the very first time, and involved other organizations such as customs, international labor unions, and others. And this in itself became a multilateral convention in the same way as the SUA Convention, and spawned several bilateral initiatives between the United States and other states of the world, including the Container Security Initiative, the Customs Trade Partnership Against Terrorism, which allowed extraterritorial jurisdiction to agents of the US security forces and customs in ports outside the United States, leading to a groundbreaking accord in 2008 between the United States and the People's Republic of China, which allowed US agents to operate in PRC ports. So we can see that in response to draconian and devastating attacks in the air, on the sea and on land, the international community came together and responded with a series of binding conventions. And the courts have not been slow to recognize that there is an evolutionary pattern to these matters. In the 1980 case, it was called Spinney's case, Mr. Justice Mustill, as he then was, heard lengthy arguments about the fate for insurance purposes of property damaged during the course of civil war and civil commotion in the Lebanon. He, as perhaps inevitably for such a distinguished figure, said this: "Methods of pursuing political aims and of waging an armed struggle do not stand still. A situation existing today might fall outside a definition formulated in the past, not because the judge or scholar who proposed it considered that the situation should be excluded, but simply because the possibility that it might exist had not crossed his mind. And this is presaged in the judgment of Lord Justice Ricks in a case called the Silver Cloud, which involved the position for insurers of the large cost of cancellation of tickets by passengers following the 9/11 outrage. Many passengers were cancelled their tour and cruise obligations under tickets, and the question arose, where did the liabilities for that fall? In a judgment which was not directed solely at the causative issues of the 9/11 tragedy, Lord Justice Ricks said this: are terrorists to be treated as combatants or criminals? The fact that everyone would agree that 9/11 was an example of a terrorist attack does not, to my mind, answer the question whether it amounted to something more. So what is the international response to piracy against this background? And there has been a significant response. During the last 10 years, the Comité Maritime International, the CMI, has paid enormous attempts to try to achieve a model law on piracy, defining new offences, widening its scope, and modelling itself on the Sewer Convention so that nations who might sign up to this model law could enact it very rapidly into their own municipal systems. Sadly, the proposed system of apprehension and reciprocal recognition and extradition has not found favour with all states concerned, and there's a significant resistance to this model law being enacted as widely as the CMI hoped. Of course, the national governments and commercial interests have themselves taken steps to try to alleviate the problems which they have faced through contact with piratical attacks. And there's been significant work done by the ICC, the International Chamber of Commerce, and its piracy reporting arm, the International Maritime Bureau. There's been enormous and very diligent diplomatic activity by the International Maritime Organization and many other national and international shipping and insurance organizations. Major steps have been taken in terms of ship identification and security, identification of problem areas and problem attacks. There has, of course, been increased naval activity and participation of governments in UAE, EU and other flotillas off the Somalian coast and in the Indian Ocean. But as become known, this is a huge task on an operational basis. There's also been significant progress on regional initiatives and accords to combat the piracy that had dominated the South China Sea for some 10 or 15 years beforehand. The Southeast Asian nations in 2004 signed an agreement called RECAP, which bound together states bordering on the South China Sea in a cooperative arrangement both to prevent, cure and apprehend piracy suspects. And this was followed by the IMO's initiative in 2009 in relation to the piratical situation in the Gulf of Aden and the east coast of Somalia, leading to the Djibouti Code of Conduct, which itself was an enhanced insurance and security and intelligence exchange, binding together nations in a cooperative attempt to try to prevent and cure. And in 2008, the United States Security Council, at the lobbying of the IMO, passed another groundbreaking resolution, number 1816, which for the first time allowed foreign warships to gain access through hot pursuit into the territorial waters of Somalia. Why has all this not succeeded? Some of the problems, I think, can be found in the case of the Alondra Rainbow, a 1999 case which involved the hijacking and piracy aboard an international freighter in the South China Sea by Indonesian nationals. The vessel followed the pattern of the Petra Ranger. She was reconfigured, repainted, her cargo sold, the crew dismissed. A new pirate crew took over the vessel and with her new definition and configuration and name started to trade her for their own criminal purposes. Broadcasts to the new intelligence agencies for the description of the vessel were put out and picked up by cargo vessels off the Indian subcontinent. The Indian maritime authorities and their Coast Guard themselves spotted the vessel, and the Indian Navy and Coast Guard were instructed to apprehend the vessel and the pirates on board, which to their great credit they succeeded in doing. All 15 Indonesian pirates were brought to shore and put on trial for piracy. But when lawyers began to examine the case, it was found that India was not a signatory to the UNCLOS Convention. and there had been no incorporation of the UNCLOS Convention into domestic law. India was not a signatory to the Sewer Convention, and whilst it was thought that the universal jurisdiction in re piracy jurientium could be advanced, lawyers were pessimistic whether it would succeed. And then the only way at the end where these perpetrators of the crime were brought to justice was on the basis of criminal sanctions still existing under 1947 legislation, a hangover from the British days in India. There was no modern piracy crime equivalent in the time between independence and 1999. As far as the UK is concerned, statutory legislation has meant that piracy is a crime that can be committed within UK territorial waters and on the high seas. And as we've seen, the UK policy is that the courts here will take universal jurisdiction against any offender, whether on a British ship or elsewhere. So what of the future and where are we now? Well, one of the problems, as has been repeatedly said, is the unfortunate and tragic state of Somalia, which for several decades now has been a country without central government, with the result in a maritime context is that its long coastline along the Gulf of Aden and East Africa is unpoliced. There is no coast guard. There is no maritime security of any sense. And as far as the shore side is concerned, there is no central government, no established legal system, and no system of criminal justice worth its name, regretfully, which could have a sanction against the havens and piratical activity which operates from within its ports. It's quite clear that whilst it may be said that the early attacks on vessels were in a sense a cry for help, as occurred in the Panagia Tinu, since then intelligence-led criminal activity has taken to the fore. The length of time and the amount of ransoms being clearly demonstrative of the fact that private gain is at the very heart of the attacks which are being made. Why can't the Western nations do more to prosecute? Why can't they establish jurisdiction against offenders? Many of these issues are very difficult to resolve, but against the background we've discussed the private law, public law interaction. Prosecutions and jurisdiction issues have stumbled on issues such as human rights, asylum of claims for asylum by offenders, offenders seeking refugee status on national warships or cargo vessels, individual national security concerns, limitations imposed by national governments on the rules of engagements of their naval vessels, restricted spheres of legal and diplomatic influence, problems of evidence, identity, and jurisdiction. All of these have been deviled the hugely laudable and hard-working attempts of organizations such as the IMO, commercial shipping organizations, the ICC, and indeed, of course, naval forces to try to prevent and cure the problem. But unfortunately, the problem is proving very difficult, and there are many of those who say that the problem cannot be solved at sea, but can only be solved ashore. And there's no doubt that if the tragic state of Somalia could be translated into a modern, efficient state with its own maritime security regime and criminal justice regime, there are reasonably strong arguments that the piratical attacks would cease. There is, of course, a lack of Western appetite for involvement in a way which, in times past, might have put an end to the activities of those perpetrating what is being done at the moment. And there's another problem. As we saw in the case of Masefield and Amlin, there is now a recognition, perhaps starting in 2002, that a ransom tariff exists. There's extensive debate as should ransoms be paid, and there continues to be a standoff between commercial interests anxious to recover property and governments, on the other hand, who do not wish to condone ransom payments. That standoff continues. And until it's resolved, and until the situation in Somalia, both ashore and along its coastline, is resolved, there's very grim pessimism that these matters may continue. And it may be worth just noting in conclusion, ladies and gentlemen, in that same case of Masefield and Amlin, an issue arose in the commercial court as to whether in the context of these piratical attacks, the payment of ransoms was illegal or contrary to public policy under English law. It was held that it was not. So maybe there's succor and comfort for those demanding the ransom and making life more difficult for those who would prefer them not to be paid. Thank you very much indeed.
thank you. We have some time for questions, about 10 minutes or so. Please raise your hand if you have a question, and when I call on you, please wait to ask your question until microphones arrive so that we can have your wonderful voice on the tape for the lunchtime lecture. See one right there, gentleman in the red shirt.
Hi. Is there an idea that the insurance companies, as the Somali problem goes on, will stop paying ransoms because it's not in their interests financially, or is the value of the cargo so much that the insurance companies are happy to pay ransoms indefinitely because it's always going to be financially worthwhile?
Well, as far as the Maysfield and Amlin case concerned, a claim for loss of value of a cargo, which was on a hijacked vessel. So that case was specific to a cargo, and questions whether it became an actual or constructive total loss for marine insurance purposes. The problem remains is that at the moment, unless an actual attack can be prevented, once it has occurred, the only solution, apart from one or two draconian and rather well-known incidents where there has been successful military intervention, in the majority of cases, as the case itself recognized, the only solution to release of ship, crew and cargo is the payment of a ransom. And this has still fallen to the account of marine insurers, whether they be insurers of the vessel, the hull and machinery, or the cargo. So I think the answer to your question comes back to the situation that unless there is a regime on shore which can act itself in a preventive way, then at the moment, even though there are edicts by governments not to pay ransoms, they recognize that unfortunately a tariff exists. And that tariff, of course, has both lengthened in time and increased in an amount. And I'm afraid the prognosis is really rather pessimistic. So I think the short answer is that absent a change of regime in Somalia and a complete overhaul of what's occurred on shore, then the continued threats of the present state exist. Will continue to do so.
Gentleman in the blue shirt. We're looking over here next.
Thank you very much for your talk. I think it's worth pointing out, further to the question that was just asked, that the insurers will continue to pay ransoms for as long as they are allowed to, but the moment that a connection is made between the piracy gangs and the insurgent groups of southern Somalia, particularly Al-Shabaab, but as soon as that connection is made, then the payment of ransoms becomes the funding of terrorism. At that stage, the insurers will be obliged to stop paying ransoms.
I agree entirely. I steered away from strategic questions because the concept of maritime terrorists has been floated in many occasions, and there have been certainly some extremely erudite articles which have appeared in the press equating the acts of pirates to maritime terrorists. And the reason why lawyers have been nervous about going into that area is the very reason, sir, which you mentioned, that once it becomes established that payment of ransoms is being made against the background of ransoms demanded by terrorists or it becomes illegal as a matter of English law under counter-terrorism legislation and indeed national legislation in the United States and elsewhere. So at the moment, there's been a significant degree of anxiety between those seeking to release ships and cargo and crews unharmed by payment of a ransom, looking over their shoulder to see whether national governments at some point will take up the cudgel, as you've said. But this brings us back to Panagiotino. How far do national governments have to act? And there is here undoubtedly a threat to the global supply chain in exactly the same way as occurred after 9/11. So you make a very good point, which I entirely agree with, a nervous one for lawyers and insurers. Thank you for asking it.
Gentlemen?
Maybe a naive question, but
Sure,
historical precedent. When I was a kid, I learned about the Barbary pirates. They went on for ages and ages, I understand. How is that resolved, if at all? And where else in this wonderful, quiet world can we get into a business as good as this is? And have there been other instances of piracy that were resolved, stamped out, or what?
Very good question. Well, as far as the Barbary pirates and Mediterranean corsairs were concerned, I think that goes back to classical times, and nation states, even in classical times, took exemplary military action to put out the threat that pirates gave. And this occurred right through to Victorian times, when the Red Sea and the Middle East was still an area of pirate activity. But the states at large running world trade took exemplary action and military action to wipe out the threat. This is still a feasible possibility, but the Western appetite for intervention in Somalia in a way which would cure this issue, of course, is an issue outside this discussion. So military intervention was the key to success in the past. Whether it will be here in the future is a matter we'll have to see. As far as other areas of lucrative trade is concerned, which you mentioned, certainly Nigeria and the South of China Sea have both shown different aspects. The Nigerian problem has been part of the ongoing dispute with the Nigerian nationals and oil companies' offshore activity. South China Sea was, like the cases we've seen, was theft of vessels and cargoes, trading phantom ships and so on. But regional agreements in Far East have put an end to the Southeast China Sea type piracy. Nigeria remains an ongoing problem, but not so much a piracy ransom problem as more robbery, theft and political motivation. As far as your aspirations for future wealth, I would hate to forecast where it could be. Let's hope there won't be one, although I wish you very well, sir. Thank you.
Can I just ask your opinion on, in terms of the current legal framework as it stands, how do the actions of Israel against the numerous humanitarian flotillas that have tried to reach the Gazan shores, how do they stand up in the current legal standings as it is today?
Well, the attacks, are you meaning the attacks from the vessels that were sent to Gaza with humanitarian aid? Yeah. Well, I think from a lawyer's perspective, whatever the motivation and execution of those attacks, they could not be classed in any sense as piratical within the definitions of which we've seen today. So were those actions to be put before a court or tribunal here, the question would be, was the motivation personal gain or some public activity? It was quite clear from what you'd see in the newspapers that this was an element, as far as Israelis were concerned, of national security. So that's a very good example, so which you raised, of the distinction between a public law act and a private law risk. So that's a very good question. Thank you for asking it.
Gentleman back there, please.
With regard to the chandlers who were seized October 23rd last year and are in captivity in Somalia, does the British government have any duty to rescue them in some way? They're not covered by insurance, I understand.
Well, again, this of course is a true kidnap and ransom situation, and a tragedy which has befallen these two people, and thoroughly innocent people. It falls outside, of course, the scope of commercial discussions, and the question there is of direct payment of a ransom by those acting on behalf of the unfortunate couple. And at the moment, as you say, there are no commercial interests, and I'm really not in a position to say, but one suspects that the British government, at least outwardly, would be unprepared to sanction payment of a ransom to release its nationals, although it has, of course, knowingly been done by other European and other nations to free nationals in the absence of any military activity. And the French clearly took a military incursion against the couple who were held on a yacht. And of course, it's a sad fact that the Navy were unable to rescue the chandlers at a time when that might have occurred. It just wasn't possible, I understand. So has the Crown got a duty to pay a ransom? It's entirely a matter of current policy. I think governments differ, but as was said by the gentleman here, I mean, the current trend of governments is to try to discourage ransom payments, even in a commercial context. So I would imagine that that policy would maintain. And unless a private venture could be launched, which has been attempted, I fear the fate of those poor people is still rather uncertain.